The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
You may be seated. This morning we have 3 cases for submission. State of Iowa versus Davis, Attorney Disciplinary Board versus Parrish, and Seeberger versus Davenport Civil Rights Commission. The last 2 cases are non-oral and they will be considered submitted as of this time. We'll have all our arguments in the first case, but I will tell you that Justice Cady and Justice Heck are not here, but they will be participating in this decision, watching the tape. Are you ready for our argument?
Yes, Your Honor.
Go ahead.
May it please the Court. Good morning. You might have noticed that I changed the direction of my routing statement when I got to the reply brief. And of course, the reason for that is I had no quarrel with what Judge Strausser found in regard to Mr. Davis's restraint of liberty as he sat in the back of the squad car. And I had no assignment of error on Judge Strausser's suppression of the results of the field tests that were conducted at the jail. After the state filed its brief, I saw that what we had was an attempt to expand this court's precedent in State v. Krebs and, in fact, overturn this court's precedent in State v. Moorhead. In Krebs, the court specifically interpreted the part of the statute that deals with the person's restraint of liberty. And it's the language that comes after arrest and says, or the person's liberty is restrained for any reason whatever. When Krebs and Moorhead interpreted, the courts in Krebs and Moorhead interpreted that language, they gave meaning to that language. They didn't.
I'm okay. I agree with you that your client was restrained of his liberty. The issue I have is the transportation to the Sally Port was for the purpose of performing the field tests. And was the Sally Port a place of detention since the purpose was to perform the field test there? It was simply moved from roadside to there because of the bad weather. I mean, it seems to me there's 2 requirements in the statute: restraint of liberty and then having been brought to a place of detention. And I'm with you on the first requirement, not on the second. All
right. Well, and if you go back and I guess I didn't ever specifically quote this, but it is clear in the suppression hearing that Mr. Davis was not free to leave the Sally Port. He was not going anywhere, and as the court
Nor
said,
was Krebs free to leave the side of the road for the field tests either.
Correct, and you know that is before the restraint of liberty, though, and that's what Moorhead clarified. Once he's put into the squad car for transport, he's not going anywhere. That's where the dividing line is between a field test and I, you know, the problem I had with the way the state is going about this is they want to use unreported cases from the Court of Appeals to make new law. And in Moorhead, that dividing line was very specifically drawn. This is the restraint of liberty that statute is talking about that triggers the right. You know, and he didn't get any freer when he got to the Sally Port and was requested to perform the field tests. In one of the Court of Appeals cases that the state is using, and then the Court of Appeals also used, the Delzer case, Judge Tabor's dissent focuses on that specifically. And she does an analogy to those field tests and why field tests are okay out on the street and not being called a sufficient restraint of liberty is because that's a Terry stop. That's just like a Terry stop. You don't have the right to counsel out there. You don't have the right to talk to anybody else out there while you're being detained for an investigatory purpose. When you put the defendant into the squad car, then you're beyond a Terry stop. As Judge Tabor said, there is a Terry stop, but there is not such a thing as a Terry transportation. So the idea is that the dividing line has to be drawn somewhere to give the statute meaning in that phrase.
So are you saying the squad car, at least the back seat, would be a place of detention within the meaning of 80420?
Well, within the meaning of 80420, place of detention has been interpreted to mean where they're taking the person, and I think that's pretty consistent throughout the case. But that kind of relates more to the delay in allowing the call to counsel or family. Whether there's
Would we have a how would this result in this case change if instead of taking to the Sally Port at the jail, he had been taken just to a public parking garage to get out of the weather to do the field test?
Well, that's a good question. The problem was that custody was imposed by putting him into the squad car, and that would be a different case. And that's kind of similar to the Sarine case, which is one of the unreported cases the state relies on, where the place where the officer was initially talking to the suspect, she was moved not too far away, but to a different parking lot. Her lawyer happened to be her passenger that night. And then the lawyer was not allowed to go over to that other parking lot for field tests. And I think clearly, and I think Sarine was decided correctly, that while the officer's out there on the street, that restraint has not kicked in sufficiently for the statute yet.
So am I understanding you correctly that if they put your client in the squad car but took him to some location other than the Sally Port that happened to be connected to the jail, it would have been okay?
Well, then in that situation, then we have custody. Then do we have a release from custody if we're in a parking garage somewhere or another parking lot somewhere? Is there a release?
I want to back it up at a little bit more than that. The weather. We can't ignore the weather.
Mm-hmm.
So you've got this situation, an alleged person who's driving while impaired, and law enforcement pulls him over for whatever reasons. Let's say we both agree that it's legitimate reasons to pull him over. Wicked weather. Okay, if we just start sending the message that law enforcement needs to do the fields no matter where you are, isn't there going to be an amazing argument against the state that how can anyone be successful on these fields in conditions like this? Aren't you virtually tying the law enforcement's hands in bad weather?
Well, no, I don't think so. I think that most people, when they're transported, are going to go ahead and do the field tests. At this point, the officer does not have the duty to tell the person that they have a right to, under the statute, to contact an attorney or family member. Most people don't do it. Most people, if they say anything, they might say something like, do I have a right to a lawyer, or something like that. And if they do, then it's triggered. Now, the question I think you're asking, Your Honor, is who's the burden upon when we have bad weather? And I think it's been decided that the unfortunate burden is on law enforcement here.
And you're saying that what they did, the reasonable accommodation because of the bad weather, is unreasonable? Or the accommodation made, you think?
It's not unreasonable. I'm just saying that then the right kicks in. There's nothing unreasonable about it.
But that's assuming then that the officer is ready to charge. Wouldn't you agree with me that this is still the investigatory stage of the stop?
It is an investigatory stage, but that's not what the statute is about. The statute is about restraint of liberty. For any purpose, whatever, for any reason, whatever, whether it's investigation or anything else, when there's a restraint of liberty, then the statute is triggered. And I think if you take a look at State v. Hellstern, and I'd like to quote Justice Waterman on a couple things here that illustrate the burden of the balancing here is upon law enforcement. And the first quote is, quote, "By providing detainees this statutory right, the legislature has deemed a detainee's right to communicate with family or counsel to be a tolerable burden upon law enforcement." Pair that with this quote then, and this is at page 363 of Hellstern, quote, "Because of the disparity in power during the detention process, 804.20 requires law enforcement to take affirmative action to honor the request for a phone call." Now, that's not exactly what your question is, but I think what this language says is that the purpose of the statute is to protect the public's right to communicate with family and attorneys when they are in custody, when their restraint of liberty is sufficient that the statute is triggered.
But Hellstern, he was already at the police station, right? And the thrust was read 804.20 together with 321J, with the critical thing being that you have a right to talk to your lawyer by phone or in person before the critical decision: do you take do you blow or not? Do you take the breathalyzer?
Right, and I mean, that's...
And in this case, he was able to talk to his lawyer before deciding to take the test.
Right. But I mean, and if you look at Hellstern, though, there was a problem with the confidentiality of that conversation was not provided. In which case, in Hellstern, you said that's the result is suppressed, and I think Hellstern is also valuable on the exclusionary question in this, which was my original question with the whole decision in the district court. And that is, if there's interference with the attorney-client relationship, then you just have to suppress the chemical test.
Right, as we did in Walker also.
Right.
Let me
exactly.
if I could, let me get back to, or let me move into a different part of the statute. Now, the statute also says part of this right is to be permitted to make a reasonable number of phone calls as may be required to secure an attorney after you arrive at this place of detention. Now, when this statute was written, there were no cell phones back then. And so it strikes me that it contemplates as the place of detention being essentially a police station or a jail or a law enforcement center, not somewhere that happens to be a location picked for purposes of testing, simply because of field testing because of the bad weather. I mean, how do you explain all that language about phone calls? It was all in there before there even were cell phones.
Well, and I don't think that the advent of cell phones here affects the interpretation of this statute in any way. And the thing is, that question, as we talked about a public parking garage or something like that, somewhere that's covered and they could have done the tests, that would be a really interesting case. But in this particular case, there's just no question.
But why is that
Once he was placed in
different?
the squad, he was in detention, and that.
But why is it different? Because on the one hand, I hear you saying the key step is placing your client in the squad car. On the other hand, I also hear you saying the key step is it was the sally port of the jail rather than the sally port of a gas station. I mean, which are you hanging your position on?
Both. When he put him in the squad car, he put him in there to take him to the jail, to the sally port. He knew exactly where he was going. And it's like Moorhead, when the court said Moorhead wasn't going anywhere. His liberty was restrained. it's the same thing in this case. Mr. Davis was not going anywhere. Now, much like Sarine, they could have taken him to a different public place to do field tests, but they didn't do that in this case. So, I mean, the legislature could do things with this statute to allow for, I mean, they could get as specific as inclement weather in drunk driving cases if they wanted to, but they haven't done that. They've only made the dividing line that restraint of liberty. And this court's precedent says when the defendant is put in that squad car to go to the jail, that statutory right is triggered. And it's triggered in this case. It was not triggered in Sarine by moving to a different parking lot, but it's triggered in this case. Any other questions? I'll yield the floor.
Thank you, Mr. Simmons. Mr. Howe?
May it please the court. Counsel. This court should affirm the Court of Appeals decision because Mr. Davis was not restrained of his liberty at the time that he arrived at the sally port of the police station. The reason I say that is looking back to Krebs. I politely disagree with Mr. Simmons' read of Krebs. My reading of Krebs is that the court, in reviewing 80420, decided that restraint of a person's liberty for any reason is not actually triggered during roadside field sobriety tests. If that's the case, then there's no legal difference between a field sobriety test that takes place at roadside and a field sobriety test that takes place at a police station due to inclement weather. Accordingly, police officers were not obliged to basically give him a phone call until the investigatory phase was done. And this is consistent also with Moorhead. I think the real key in Moorhead is not so much that he was placed in the car. The fact that he's placed in the car is an indication that, as the court said, the investigatory phase was over.
But didn't they in Moorhead say that the place of detention was the backseat of the car?
Forgive me if I'm mistaken. I do agree that Mr. Moorhead was detained at the time he was placed in the car in that case, but I believe the reason is that the investigatory phase was done. He was not under arrest, technically speaking.
But here's what we said in that case.
Please.
Moorhead's parents arrived at the scene of their son's detention. That was the backseat of the car. That's what we called it.
Certainly, but I think we're getting hung up on the fact of the placement in the car, and we're kind of overlooking the actual legal phase that we're in, and it's not investigation.
But the statute then goes on to say, or restraint of a person's liberty for any reason whatsoever. It doesn't distinguish between investigatory stage and non-investigatory stage.
I think that's what Krebs instructs. And again, reading Krebs and Moorhead and 80420 and 321J together, I think it leads to the conclusion that the investigatory phase, when that's completed and implied consent is invoked and a person is brought to the station, at that point, they are to be afforded their phone call to obtain counsel.
Understand Moorhead, correct me if I'm wrong. The investigatory stage was over when he was put in the car. He had failed the field sobriety test, unlike the individual here. And so he's put in the car, but the issue was that he wasn't allowed to make the phone calls once he got to the station.
That's correct.
And that's why I ask, place of detention, place seems to me to mean a physical place that would have access to a telephone where someone would normally be detained, as opposed to this concept of restraint of liberty. I think you have to have both.
Sure. Oh, and I 100% agree with that, Your Honor. And your point's well taken about the age that 80420 was created in, and the proliferation of cell phones had not occurred. Phones were a physical construct that would be at a location.
Proliferation, there weren't any.
That's correct. Yes. And I think it also raises a point that Justice Christensen was raising, which is that theoretically, it seems to create a trap for the state in a certain sense, in that if we're not permitted to take them to the station to complete FSTs, then do we have to afford them a phone call if we do stop at a parking lot or we do stop at a gas station? And if those phones aren't for public use, what occurs then if no one has a cell phone? I think a cogent read of the statute and this court's case law is that once field sobriety testing is done and the person is brought in custody to the police station for the purposes of implied consent testing, a chemical test, at that point, 80420's right to a phone call ripens, essentially. You absolutely are permitted to make the phone call at that time. I would note also that I think one thing that I wouldn't say has been overlooked, but I think bears mentioning, is also that the delay cannot be an unnecessary one. And even if this court were so inclined to find that a right to a phone call would have attached at the moment he arrived at the Sally Port for field sobriety testing, I don't think the 12.5-minute delay to complete field sobriety testing during the investigatory phase is an unnecessary one. Admittedly, it is an unpublished opinion, but I think the Smith case from the Court of Appeals, which I cited in the state's brief, is a persuasive analysis of this question. We're not trying to say that there's a hard minute deadline, but there are certain things that do happen once a person is brought to an ultimate place of detention that have to occur, and the phone call need not, we don't need to put a phone in their hand the minute they walk through the door. I would also like to point out that Mr. Davis's right to confer with his attorney was honored in this case. He was able to make contact with his attorney. His attorney came to the station and provided him the advice that 80420 under this court's case law promises him, advice as to whether or not to take and take a chemical test. At that point, he decided to take a chemical test, and the results were admitted.
What if his mother was in the car, or his lawyer was in the car with him, and he gets stopped, and he says, I want to talk to my passenger before I decide to do anything. Can the police officer stop him from doing that?
Roadside, Your Honor?
Yes.
Yes, they can stop him. At that point, the officer's investigatory phase is ongoing, and you don't have a right to counsel under Krebs.
What happens when they put him in the car to take him somewhere?
At the point that he's in the car?
Put in the car, and under the SPAC situation, they're going to take him somewhere else to do it.
Sure.
Does he have a chance to talk to that lawyer or passenger or family member before he's taken?
Sure. Again, strictly speaking, looking at the statute, I believe the answer is no. To the point that Justice Mansfield has raised, he hasn't been taken to the place of detention at that point, and so the right would not attach. However, once he arrives,
But you don't recognize the car as being a place of detention. He couldn't leave that car when they're transporting him to the Sally Port, could he?
say that one more time.
He couldn't walk out of that car and say, I'm not going with you, could he?
No, I don't believe so. The point I'm trying to make is that the word taken in the statute has to mean something, and he hasn't been taken anywhere yet.
What difference does it make that he was taken to a Sally Port attached to the jail as opposed to some other sheltered location?
In the state's view, none, Your Honor. The location essentially does not mean anything because we're still, one, in the investigatory phase, and two, essentially, I don't think it makes sense to put any specific importance on the actual temporary detention. He is being detained for an investigatory purpose, but it's not enough. It's not a restraint of liberty. Finally, I would note that I think the Court of Appeals assessed the question correctly when they found that the district court made an error in suppressing the materials after the arrival and beginning of field sobriety testing up until the point of the phone call. I think reading the statute in conjunction with this court's case law, 80420, while the invocation certainly was valid, he asked for the right to the phone call, and that had to be honored, but it only had to be honored once the right to the phone call ripened, and that occurred after field sobriety testing was complete and implied consent was invoked.
I have a question. We're talking about how simple and easy it is to have cell phones. What is the harm in letting him have a quick phone call, even at the side? Yes, I agree that the statute probably was created when a phone was physical, but now we do know they are extremely available.
Absolutely. Your Honor, I don't think there's any harm in it. I will say that by if we're looking at the statute, it's not a violation of the statute to deny the phone call. That would be the state's position in this case.
Don't you think the legislature knows there's a proliferation of cell phones? They haven't done anything to change the statute.
I would agree, and in fact, Your Honor, I would suggest, given the age and the vintage of this court's case law in 80420, it suggests a certain amount of legislative acquiescence, that they're comfortable with the balance that's being struck between individuals at roadside and the state in this instance. As this court has noted, we read 80420 pragmatically, and I would also note that it is a statute of general application. It's in our arrest chapter. It applies, the title of it is Communications by Arrested Persons.
And again, I go back to the language. It says, a peace officer having custody of a person arrested or restrained of the person's liberty. So Mr. Simmons' point, and I take his point, is that his client, Mr. Davis, was restrained of his liberty when he's put in the squad car. Then it says, shall permit that person without unnecessary delay after arrival at the place of detention. So it sounds like even back then, they contemplated a place of detention which would not be the vehicle that's transporting the individual.
I would
Because
agree.
they may not have had cell phones in 1962 or whenever this statute was written, but they certainly had squad cars. And under that analysis, how is this Sallyport a place of detention? Because it's really no different from any other location that could have been picked out to perform the field tests.
I absolutely agree, and I think that is consistent with the larger taking away from Krebs, which is that during the, and I'm sorry if I'm being reiterative at this point, but during the investigatory phase, you are not being detained in the nature that 80420 anticipates. Accordingly, you don't have a right to a phone call during that time. That also bolsters your point, Justice Mansfield, that the location really doesn't matter. It's not until you're being taken to the police station, which has the phone, that the right ripens and you're able to make the phone call prior to getting advice about whether or not to comply with implied consent testing.
At the Sallyport, would he be free to walk away?
No, Justice
He
Mansfield.
was
I agree.
detained at the Sallyport by the officer. If he went to a private gas station, would he be able to walk away?
No, I agree with you wholeheartedly that he is being detained for an investigatory stop. That's absolutely consistent with the state's position. What I am saying, though, is that restraint of their liberty for any reason whatsoever is distinguishable. They are not synonymous, and accordingly, because they are not synonymous, it requires, as Justice Mansfield pointed out, that they be taken to the place of detention, and that detention is longer than what we might anticipate as
Do
an
we have to
investigatory
overrule Moorhead where it says when he was in the back of the car, he was detained?
I don't think you'd have to overrule it, and that's for the reasons, and I'm sure you'll correct me if I'm mistaken, but I read Moorhead to say that when the investigatory phase is done, is by all purposes arrested, the right has to be complied with. I would also note that I don't recall Moorhead being so much about the timing of the phone call as whether or not the right was denied in and
He
of
asked for the
itself.
phone call in the back seat of the car.
Sure.
Because his mother was yelling at him, "You're grounded." I remember that
Absolutely.
case.
Absolutely.
And then he asked for the phone call in the car, and the officer says, "No, you have to wait till we get to the station." When he got to the station, he didn't get the call, and we suppressed the breath test on the grounds that he didn't get to make that call while he was in the back seat of the car.
I don't take Moorhead to mean that. I agree with you absolutely that the test had to be suppressed because Mr. Moorhead's 80420 rights were violated. He never received that phone call. I think that's consistent with this court's, yeah.
The case points out Moorhead never asked for the phone call at the station because he thought the officer would have told him, "Now it's time to do your call." So he never really asked for the call at the station.
I think the state and other litigants have previously been very preoccupied with invocation and the timing of invocation, and that's not really at issue in this case.
Language I see in Moorhead, maybe I'm reading it differently. Here's the holding. As a consequence, the police were obligated to honor Moore's request, which he made in the car, that's correct.
Correct.
Without unnecessary delay after arrival at the place of detention, in this case, the police station. That's a direct quote from the case. And doesn't that suggest that the place of detention is the police station, not the vehicle?
Absolutely. I'd like to just briefly touch on a point that I alluded to earlier, but the idea that, and it's one that this court has not previously confronted by my research, but the idea that even if a violation of 80420 occurs, that the violation initially can be subsequently cured so long as the individual is able to, has the right honored and is able to make phone calls. That it hangs in the wings of Viator, where they suggest that ordinarily, if someone is permitted to make phone calls, the right is validated. And I think the district court ultimately reached the right decision in this case, even though it made a legal error initially in saying that the breath test results should be admitted where the individual is given their right to the phone call. Accordingly, because 80420 was not violated at the time that Mr. Davis was placed in a vehicle and brought to a Sally Port of a jail for field sobriety testings, because he was eventually permitted to make as many phone calls as he liked, made contact with his wife and his attorney, and because his attorney eventually arrived at the station, his rights under 80420 were not violated, and if they were violated, were certainly vindicated prior to the time chemical testing occurred. The state would request that you affirm.
Thank you, Mr. Howe. Any rebuttal?
Yes, Your Honor. Thank you. I guess for what it's worth, Moorhead came down in 2005, and the court can take notice there were plenty of cell phones floating around in 2005. I don't think that had any effect on the court's decision.
No, but you agree that they characterize the place of detention in Moorhead as being the police station, not the vehicle, right?
Correct. And, well, in Moorhead, they actually say the place of detention is the vehicle, as Justice Wiggins said.
No, I
But-
just quoted. Did I quote it incorrectly?
Well, I can't say right now. I don't have it in front of me. But in any case, it's one of those things that doesn't matter. He was taken into custody in that car. He was taken to the place of detention. He never left the place of detention. He invoked the right before they left while he was in the car, which is exactly what Moorhead did. The question is, if you were out on the street doing field tests and the person had a cell phone, could they call somebody in the middle of the field test? And no, the officer, because he's conducting a Terry stop, can't prevent the suspect from doing that. In fact, in the Krebs case, you see the difference in technology between 1997 and 2005. Mr. Krebs actually got a page from his wife in the middle of the field sobriety test, and the officer would not allow him to call his wife back on the page. So, and there was no error raised on that, and I think it's pretty clear in Terry stop law that you can do a pat down if there's a reason to believe there's weapons. The officer can control the situation out there on the street for the purpose of a Terry stop. But as Judge Tabor said in Delzer, there is such a thing as a Terry stop. There's not such a thing as a Terry transport.
Sounds like you're almost saying the place of detention is a geographic construct. I mean, correct me if I'm wrong. I mean, we have some colloquy going on with other members of the court about the function of the stop and whether it was Terry type stop and an investigative stop and just happened at the Sally Port. It strikes me that you're almost saying, well, the police station has this kind of geographic configuration. I mean, it's almost a title issue. I mean, you're on the property that is the police station, and that triggers place of detention. Am I being unfair to your position?
Well, I'm sure you're not being unfair, Your Honor, but
How about wrong?
well, I just don't understand why we need to determine that for this particular case. He was put in the car. Actually, his cell phone was taken away from him by the officer, and then it was taken away from his wife, who was on the scene. So, once he was put in that car, he was just like Moorhead. He wasn't going anywhere except
I don't
to
think there's any
jail.
question about that. But place of detention on its face could mean a number of things. He was restrained of his liberty. I don't think there's any question about it when he's in the car.
Right.
And on one level, you could say place of detention means the car because that's where his liberty is restrained.
Yes. Well, I guess we could say is putting in the squad car then as he arrived at the place of detention in the squad car. But again, I don't.
Well, but I'm just having trouble with the notion of if instead of going to the Sally Port at the police station, if they would have gone across the street to a Sally Port to do the implied consent procedure, that would be okay? I mean,
In other words, if it were not a locked facility, or you were.
well, yeah, I mean, it was just across the street.
Public
It was
parking
20
garage.
feet away, well, maybe it'd be 80 feet away, however many across the street gets you. The exact same configuration out
Yeah.
of the weather.
Well, and then I think there'd be a real question as to whether his his liberty was sufficiently restrained in a short trip to another.
Couldn't walk away, I mean.
Yeah. Well, he probably couldn't walk away, but that's kind of what the legal distinction is here. You know, and there's all kinds of things that people have done between Terry stops and custody for decades about where is the dividing line. But I think Moorhead just made it very clear. When you're put in the car and you're going to the jail, which is what the case was, the right under 8420 is triggered.
And I respect your arguments, but I mean, the officer, I think, made it clear to your client, didn't he? Said, we're going to the Sally Port to conduct the testing, and if you pass the tests, you're going to be free to go. And in fact, I think he said, I'll give you a ride home if you pass the test, if you want it. Isn't that right?
Yeah, I believe that's exactly what he told him. But the problem is he never was released from custody. So,
Well, isn't that because he failed the test? But counsel, what should have,
well, if he had refused the test, I think it would have been a whole different ballgame. You know, he said, if you pass the test, I'll
Okay.
let you go. He didn't
What-
say, if you refuse the test, I'll let you go.
what should the officer do in a winter storm that you can't, as a practical matter, do field tests, or at least the balancing tests, walk a line, the one-leg stand, et cetera, out in a snowstorm? What should the officer do?
The officer should do exactly what Deputy Cardenas did here, to go to a safe place, and even if it's a jail. But it's, you know, it's just like tie goes to the runner here because it's bad weather. It's, you know, like your language from Hellstern, you know, the interest of this statute is in the public's right to communicate, and that is triggered when there's custody, whether it's because of the weather, because the deputy would just rather do it in the Sally Port for no apparent reason. It doesn't matter what the reason, for any reason whatever. The weather can be that any reason whatever. And you just, the way the statute still stands and the way Moorhead is written, this particular case, and you know, there are 1,000 hypotheticals we can spin off of this case, but for this particular case, the precedent of Moorhead is clear. The restraint of liberty is clear. The officer had an affirmative duty to see that that request for the phone call was honored upon arrival at the place of detention, wherever that was. It wasn't done when they got to the jail. You know, it's clear in the record the deputy knew exactly why he wanted to talk to his wife. He knew exactly why he wanted to talk to his attorney. The deputy even admitted in the suppression hearing that the wife told him that he wanted to talk to his attorney before deciding whether to do field tests. So, you know, I think the intent here is not very good when you match it up with the liberty interest that's protected by the statute. And though the intent of the officer is not the key here, it certainly supports that good policy swings the balance in favor of the person who's picked up by the police, as opposed to the police when there's a question like weather involved. Have any other questions?
Thank you, Mr. Simmons.
Thank you so much.
The case is now considered submitted. You may recess court.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.